After months of trying, the judge presiding over a Georgia case where a black man was using the stand your ground defense as his defense has been removed. Marcus Wilson, a biracial man, was driving with his white girlfriend when a group of white teens accosted them in a truck. Wilson, fearing for their lives, fired his weapon, killing one of the teens. Wilson's attorneys claim Judge Michael Muldrew had issues with bias and prejudice against their client. Reverend James Woodall from Just Georgia joins us from Atlanta with more details. Reverend Woodall, thank you so much for making time to join us here on Roland Martin Unfiltered on the Black Star Network. Let's get started with the question and the issues right here at this outset. How were you all effectively, not you all from Just Georgia necessarily, but the attorneys and the activists are on the ground there, how were you all able to demonstrate the racial bias against the client that ultimately would hopefully get us closer to a more fair trial?
Most definitely. First, thanks for having me. One of the very first things we saw was that there was a difference in how the judge was treating witnesses in this case. And the judge that ruled or issued the ruling that recused Judge Muldrew identified that as such. But also, one of the lead defense attorneys, Attorney Francis Johnson, was actually held in contempt of court, as well as detained and arrested on the day of the immunity hearing. Was also part of that kind of concern that we had was that any individual should be able to have the counsel of choice. And when you have a proceeding in which a sitting judge essentially tells some of the other lawyers on the defense team that this person will not be able to participate in any legal proceeding because he's in contempt, that deprives a defendant of their right to counsel. And so compounded with all the other things that happened in this case, the ex parte communication, the appearance of prejudice against some of the witnesses, then the senior Judge Karp did agree with us that ultimately this judge was unable to be impartial, or at least appeared to be impartial, and thus issue a ruling that essentially put another judge on the case.
So many of us observers particularly black observers, will watch cases and conclude that person clearly is biased, but bias and discrimination, particularly as is practiced in the United States courts, are always very difficult to prove. Were there anything that you guys saw that you knew that you've seen before that this would be able to stand up in front of another judge in another court?
Well, one, is this question about a notebook in which the prosecutor hands the judge a notebook that includes emails between Marc and his family while he's in pretrial detention that was not previously seen by the defense team. And in fact, when the courts were made aware that the defense team was not, in fact, had any knowledge of this notebook, the judge then responds in a very aggressive manner in which Attorney Francis Johnson essentially says, I want to establish chain of custody. I want this to go to the clerk of court so that we can have it in the record, to preserve that record so we can ensure that there's a very clear understanding of what had just happened. And instead of allowing that to take place, the judge responds and held Attorney Francis Johnson in contempt of court, and that's where this entire process began.
I appreciate you walking our viewers through that. Just quickly before I bring the panel in, because I would love for them to be able to engage with you. When you say contempt of court, for those of us who may not be completely familiar exactly what that is, what is the judge then doing to the defense attorney when they put them in contempt of court?
Well, a contempt action is simply a public reprimand, if you will, that says person who is held in contempt of court has not followed the court's order, and the court's order in that particular situation was the binder in which was improperly submitted to the court was not in possession of the person who it was intended to be in possession of, which was Attorney Francis Johnson, who had it. The judge asked Attorney Francis Johnson to give it back to the judge, but instead he gives it to the clerk to, quote unquote, establish chain of custody, because the judge simply wanted to give it back to the prosecutor so that they could undo their wrong, as opposed to saying, hey, I'm a judge, I've received improper evidence, let me let the entire court know in front of everyone so that there's no question that I am being improper in my behavior as a presiding judge. That did not happen. And so that's when the whole action of contempt comes. And I also name that action is currently sitting before the Georgia Court of Appeals to really determine whether or not that was a improper action done on behalf of Judge Muldrew. And so the courts are ultimately going to determine whether or not that was improper or proper. As Judge Karp said, that Judge Muldrew could not also be on this case. And so there's several things in this case that's just completely not only wrong, but shines a light onto how court and the judicial process in South Georgia actually works.
We appreciate you breaking that down, and we know that with Super Bowl Sunday coming up, more or less you told us that if the Los Angeles Rams jumped offside, the referee told them they can get back on side and it won't be any problem, and somebody from Cincinnati had to later throw a challenge flag, and that's what you guys in the defense team did, and we're grateful you did that. Let's bring our panel in and have conversation. Again, we're joined with Reverend Jeff Carr, Dr. Julianne Malveaux, and Lauren Victoria Burke. Lauren, I'm going to go to you first. When you hear about something like this in Georgia, are you now excited that some of those activists there that are doing the work, activists, journalists, and others, are actually seeing the fruits of their benefits? Because unlike in Minnesota, we're actually seeing something that looks closer to justice coming to fruition.
Yeah, no, that's true. I do think all of this activism that we're seeing is definitely going to bear fruit at some point. I would be sort of interested to know what the record is for Stand Your Ground in Florida and in Georgia with regard to Black people, whether or not it has been successfully used by anybody African American. Because as we all know, when these laws change, they're disproportionately used in a way that doesn't benefit us. But you do see, of course, that the activism we've seen over the years since Trayvon Martin in particular does, of course, bear out. I mean, anyone who says that activism doesn't work or getting in the streets doesn't work is kidding themselves. And what we just saw in Minnesota, I mean, they should be interrupting press conferences. They should be in the streets for that. Nobody should be shot dead sitting on their couch at 22 years old. And this is not the way the system should work. So obviously, in Georgia, obviously a different state, a different place in the American South. But we do, to answer your question, we do see activism working.
And Reverend Woodall, do you have any information on the rates or the efficacy of the Stand Your Ground defense with regard to African Americans and white Georgians?
Most definitely. And it really breaks down into two particular points. And let me be very, very clear. Justice has not been served in this case. We have a young man who is sitting trial for murder. He has been in pretrial detention for literally over 600 days. Without a bond, he's never had a criminal offense in his entire life. And yet this prosecutor is being very adamant, as long as his former judge, to keep him behind bars while he awaits trial. So that's number one. Number two, as relates to Stand Your Ground, there are two particular process points in which you see a disparity. One is the pretrial immunity provision within Georgia Stand Your Ground law that says you shall be immune from prosecution, meaning you don't even get to go to trial because under Georgia's Stand Your Ground law, you have demonstrated you had a reasonable fear for your life. That term, reasonable fear, reasonable suspicion, is really the crux of where you find that disparity, because what's reasonable for a Black male who is driving downtown Statesboro with his white girlfriend, and you have a drunk car full of white teenagers who are drunk while driving while underage, is not reasonable for him to fear for his life. Whereas a police officer in the same circuit, it is reasonable for him to suspect that a man who is not armed, who is driving a broke down car, is shot dead within 2 seconds of that officer getting out of his car. The same district attorney makes that determination that the white police officer is reasonable, has responded reasonably, but Marc Wilson did not. And so you see that disparity there as well.
Dr. Malveaux, I'm going to come to you because Reverend Woodall offered the idea of reason. And as soon as I hear reason, I think about all those philosophy classes that had my head spinning around and around and around. And so, but Dr. Malveaux, how are we, the lay public, how are we supposed to wrap our head around language in legislation that involves the word reasonable, whether it be for law enforcement officers, whether it be for the ways that citizens engage with one another? How help us guide our thinking around how we should hear the word reasonable and move forward?
Ray, that's such a good question, because reason has to be shifted through a filter of where you are and what makes sense. And we can go through our history and talk about the reasonableness of a predatory capitalist structure that is designed to oppress Black people and the ways that we attempt to live in it, attempt to be within it. I'm thinking has nothing to do with this case particularly, but perhaps more generally, about the number of Black men and women who were incarcerated during World War II because they refused to fight for our country. Now, reasonable people would say, why would they fight? What would they do when people were being lynched even as they came home in uniform. But because of the law, it seems that that was unreasonable enough to incarcerate these people. Literally, one man died incarcerated because he refused to fight for the United States, which had never fought for him. So fast forward to look at this particular case. You have a black man in a truck with his white girlfriend, minding their business, bothering no one, and a group of intoxicated, unreasonable white teens become enraged. What's reasonable under those circumstances? Is it reasonable for this man to defend himself and his girlfriend? Or have been reasonable for him to allow himself to be beaten, battered, bruised, and perhaps even lynched? We don't know the answer if we don't allow ourselves to think about the various ways that we process the issue of reason. And so when we process the issue of reason, what I would ask white people to do is to say, what would you do if it happened to you? What if you were driving through Harlem with your white girlfriend and a bunch of mad brothers decided they didn't like the optics, and so they decided to surround your truck? What would you do? And would that be reasonable? And those are the kind of conversations, they're difficult conversations. You know, Ray, they're difficult conversations, but the conversations that we have to have about what reason means and to whom. And because we don't have one United States of America, I must tell you, to this day, I chafe when people pledge allegiance to the flag. I pledged it for 5 years as the president of Bennett College because I want to set a good example for my young ladies. But I can't do it anymore. I put my fists over there and I say something. The divided states of America, and to the division for which it stands, two nations under God. But because we don't have a simple, our binding value is racism. Racism is part of the cake that the founders baked when they created America. Part of the cake. We can't take the cake apart and say we want to take the sugar out. The racism is the sugar, or the flour out. The flour is the sugar. And so this whole notion of reason has to be parsed through where we are. And if there are too few white jurists who will see it our way.
Reverend Woodall, let's look at the cake and the flour and the sugar that Dr. Malveaux just told us about. We would be remiss if we didn't acknowledge that this is an interracial couple. How has that dynamic influenced the reaction of people on the ground, and those that are activists both in support of our dear brother, Mr. Wilson, and those who are critical of what they saw in the killing of the white teen? How is that inflaming the tensions in Georgia?
Well, one, it reflects a very unique reality that this family is a biracial family. This Wilson family has been supportive and made sure that, you know, anything that they needed to do to ensure that Marc got not only a fair trial, but was able to have the necessary resources to be able to have a sturdy and a very zealous defense. But one of the things I would be interested in really talking about to this latter point is that this district attorney's office has never, in a community where over 30%, 40% of the entire population not only is African American, but you have an overwhelming majority of this population, which are college students, Georgia Southern University, my alma mater. And in that district attorney's office, there has never been an African American to serve as an attorney in any capacity, a receptionist, a legal assistant, or of any capacity. And so when you talk about reason, what a white person, and now we've had the first woman to be appointed or to be elected as district attorney in Daphne Totten, but there's never been an African American or any minority for that instance or person of color in that office. And so when you talk about what the expectation is about who considers what to be reasonable, that's where you know that context is coming from. But as it relates to the biracial nature of their relationship, you know, people have their commentary as to, well, this should happen or that should happen. But at the end of the day, what we see is this is a black man. This is a black brother who is literally being prosecuted and possibly lynched because he thought it not robbery to defend not only himself, but his partner. And that's something we cannot overlook, and it's something that we will continue to fight zealously against.
Reverend Carr, I want to give you the last word on this. We heard earlier the idea of justice. Reverend Woodall said justice has not been served, and that came following me alluding to more justice is present. But I know that our spiritual teachings lean us toward what this question of justice ought to be. As you hear all the conversation that we've had thus far, where do you see justice in the midst of this?
I think I see justice in understanding what is going on and then taking agency in making a change. We often get this information and it can depress us. But I always want to remind people that during some of the hardest and most difficult times of our people in history, there were always people who said, we're not going for it. There was always a Sojourner Truth. There was always a Nat Turner. There was always a Harriet Tubman. There was always someone who saw the system the way it was and decided that there was another way forward, and so they did not give up hope. I want to commend Reverend Woodall for the work that you're doing there. It made me think of a Sterling Brown poem, and I don't know if you all remember it, but it was called Old Limb, and I encourage people to look it up. But there's something that he said that really sparked my mind to come to life on this topic, because when we ask what happened to Marc Wilson, and we see that he was followed by a group of white teens, one of the lines says, they don't come by twos, but they come by tens. If you've ever had to deal with people who operate from a space of cowardice, and you know that they don't come by twos, but they come by tens, the poem goes on to say, they got the judges, they got the lawyers, they got the jury rolls, they got the law, they don't come by ones. They got the sheriffs, they got the deputies, they don't come by twos. They got the shotguns, they got the rope, we get the justice in the end, and they come by tens. When we're looking at this space here, we are called on. We are the change that we are looking for, and we have to put ourselves in a position where we remain informed, where we're not afraid to stand up and put ourselves on the line. And one of the ways that we can put ourselves on the line is by building and supporting independent institutions so that we're not worried about our livelihood. I always have to shout out the young activists, particularly the sisters down in Georgia and spaces like that, because they are bold enough to say, while I am young, while I don't have many things on the line that the older generation might have on the line, while I'm not carrying a mortgage that can be taken out from under my feet at any given moment, I'm going to stand, I'm going to speak, and it is our job to support them. I wanted to ask something quickly to Brother Woodall, if he's still on. When I was teaching community organizing, I taught a concept of taking little bits and pieces to start moving toward the big piece. If you say crime, and I want people to be involved in crime, you never can get rid of crime, so people feel deflated when they don't see they're making a dent. But when you take one specific issue at a time and take a chunk out of it, people begin to be empowered, and then more people come. In the old days, they used to say it only takes a spark to get a fire going. How much does this recusal of this judge amount to a small win in the larger picture? How good is this to the larger case that we're looking at here?
Well, to answer that question, this has been a very long process. In fact, Judge Georgia was birthed out of the murder of Ahmaud Arbery. And when you talk about that case, we had all the national heroes, but most of them didn't talk about the work that was actually happening on the ground. So this is a continuation of some of the organizing that was done. And to your point about Black women, a lot of our coalition is amazing Black women who have been there since day one, ensuring that we supported our people. And so we talk about citizens arrest, right? Georgia being the first state in the country to repeal the ability for a private citizen to be able to arrest another private citizen, which was birthed out of the Reconstruction era, right? And so when you talk about this particular case, this is a continuation of how do we inform our communities about private interactions between one another. And so when you talk about this particular recusal effort, this is saying now that we have this judge unable to be impartial, let's get someone who is going to be objective. Let's get someone who will look at the facts and be able to make a determination based on the art of law, right? Not your own personal opinions about what he should have done, what he possibly could have done. What does the law provide an individual able to do? And so once we get beyond this case, we're going to have a conversation about what does it mean to have the ability to, quote unquote, stand your ground. Should we have a duty to retreat? Should there be a responsibility for private citizens to de-escalate uses of force? That's not the law right now. And so if we want to talk about what he should have done, that's a conversation for the Georgia General Assembly, which is a conversation we are very much so engaged in. But right now, we need due process. We need a judiciary that is able to analyze facts and evidence and make a determination based on that. And so we'll continue to fight until this case is concluded.
Reverend Woodall, before we let you get out of here, you know, we black folks, if we want to pass the plate because we like what they doing down there in Georgia, just Georgia, if we want to send our love and support, maybe I don't have any coins to give you guys, but I want to send an email of encouragement. How do we get in touch with you? How do we reach out? How do we show some support?
Yes, we do have a legal defense that we're trying to ensure that Marc gets a zealous defense. So you can follow us and follow this case along on Twitter and Instagram at @AJustGeorgia. Again, that is at @AJustGeorgia. And if you want to continue, I will be also doing some specific updates. You can follow me at IMajorWish. Either way, or the family has their own page at Stand With Marc or Justice for Marc. There's 2 different platforms on Instagram and Twitter. And so you can follow all of us so that we can stay plugged in on what all we can do to ensure that justice truly is for Georgia.
And we will be sure here at Roland Martin Unfiltered on the Black Star Network to be sure that we tap back in with you guys whenever you need to amplify a message beyond the confines of the great state of Georgia. Reverend Woodall, thank you so much for your time today.
Thank you.
Folks, back to our Roland Martin Unfiltered video in just one moment.
Time to be smart.
Roland Martin's doing this every day.
Oh, no punches!
Thank you, Roland Martin, for always giving voice to the issues.
Look for Roland Martin in the whirlwind, to quote Marcus Garvey again.
The video looks phenomenal, so I'm really excited to see it on my big screen.
Support this man, Black Media. He makes sure that our stories are told.
See, this difference between Black Star Network and Black-owned media and something like CNN.
I got to defer to the brilliance of Dr. Carr and to the brilliance of the Black Star Network.
I am rolling with Roland all the way.
Honored to be on a show that you own. A black man owns the show.
Folks, Black Star Network is here.
I'm real revolutionary right now. Roland was amazing on there.
Stay black. I love y'all.
I can't commend you enough about this platform that you've created for us to be able to share who we are, what we're doing in the world, and the impact that we're having.
Let's be smart. Bring your eyeballs home.
You can't be Black-owned media and be scared. You dig?